Okay, today is Tuesday, November 29th, 2011. This is Learning Module 7 in Forensic Interviewing of Children. And, this section is focused on the payday here. We talked a lot about different issues surrounding kids and their development, how they perceive the world around them, how to speak to them, and those kinds of things. And we want to try to pull it all together now into a coherent strategy for interviewing kids. Now, there was a time many years ago where forensic interviews of children were non-existent, where investigators or child protection workers would simply engage the child in free conversation without any structure. And oftentimes that free conversation would mislead the child or not be the ideal way to interview a child. It's only in light of cases that we became familiar with in this class, like State versus Michaels and Little Rascals and the McMartin case and others, it's only because of those cases that there began a movement towards protocolization of child interview practice. And that is creating a template or creating a model or a coherent strategy or a written strategy, a practiced written strategy that guides forensic interviewers when they're interviewing a child about alleged sexual abuse. And most of these protocols are about interviewing kids about sexual abuse. Although we're going to look at some strategies for interviewing kids who may have been physically abused towards the end of this semester. So there was a lot of research, and you read some of this research. We went over some of this research, pointing out how vulnerable kids can be, how impacted by suggestibility and misleading questions they could be. There was a lot of research throughout the years that was directed at exposing the failings of child protection and law enforcement and those who interview kids. Now, you had this research in the very beginning that said, well, kids' vulnerability to suggestion is overstated, their vulnerability to be misled is overstated, and they're actually pretty good at remembering stuff. Then the pendulum swung the other way, and we had all this research like Sam Stone and these other studies that showed that kids can be misled. The mousetrap study, kids had false memories. So the pendulum swung the other way and said, wait a minute, can we really believe these kids? And although there's still research on both sides of that issue, or those issues, thankfully the movement in the research is towards what can we do to be better interviewers? How do we investigate cases in a way that's forensically defensible? And that kind of thinking, that kind of worldview when it comes to child abuse investigations is in part responsible for the rise of forensic protocols. So now the focus isn't so much on, well, kids are really good at this, well, kids are really bad at this. The focus is now recognizing that sometimes they can get it, sometimes they can express themselves, sometimes they can be interviewed in a way that develops credible, responsible information, and sometimes they can be misled and interviewed in a way that corrupts their recollection and results in poor and unreliable information. Knowing that, what can we do to interview kids better? How do we avoid the pitfalls of poor interview practice, and how do we enhance proper interview practice? And one way to do that is to create a protocol. At least one way designed to help accomplish that is to create a protocol or a template or a set of guidelines that govern how to interview a kid, how to interview a child, and how to follow through with that interview and do it in a responsible and reliable and credible way. So you have the rise of protocol movements. And if you look in your readings, one of the last handouts or PDFs is called The Future of the Protocol Movement. And that's an article that was authored by Deborah Poole and Jason Dickinson. Now, Deborah Poole is a psychologist from Central Michigan University, and Jason is from Montclair State. His offices are right near where we're seated. And Jason and Deb Poole wrote this article called The Future of the Protocol Movement, commentary on Hershkowitz, Horowitz, and Lamb, 2005, that were among your readings. And they make a few observations there, including the observation that there are a number of different protocols, a number of different strategies out there. Now, each one of these protocols has their own proponents or believers. Some think that their protocol, obviously if they embrace it and they recommend it and they teach about it and they research it, they're going to conclude that this is the better of the protocols. And anyone who advocates for one particular protocol over the other is likely to be biased and involved or a sponsor or somehow connected to that protocol. Now, I think Deborah Poole wrote the Michigan Protocol. The State of Michigan Governor's Task Force on Children's Justice and Family Independence Agency, I think they promulgated a protocol probably around 1998. I remember I was out, I think in Chicago, at a conference, maybe in 2000, where they presented on the protocol. The protocol was finished, and they introduced it to the world. And there was a statute. There was political pressure to design a protocol, as I recall. And it became the law of the state of Michigan that you had to follow this protocol. There's also the NICHD protocol. Excuse me. Thank you. There's something from Canadian researcher John Yule called the Stepwise Protocol. There's something called the Narrative Elaboration Protocol. And there is the Corner House Finding Words Protocol. And there probably are a few others worldwide. Now, I'm an advocate of the Corner House Finding Words Protocol. That doesn't make it right. That doesn't make it the best. But I think that's the best protocol for frontline investigative interviewers, child protection workers, municipal detectives, district attorneys, investigators. I think that protocol is ideal in that context. But as I said a moment ago, I have an investment in that protocol. So I'm going to like that one the best, or I wouldn't be involved with it. The good news is that there's a movement towards protocols. The good news is that people think we ought to have protocols. The good news is that people appreciate and understand that we shouldn't simply walk into a room with a child and engage in free discussion. or free play with anatomical dolls. The good news is that there is a movement towards, and many jurisdictions embracing, among all of the protocols, an empirically supported strategy for talking to kids. An empirically defensible strategy for talking to kids. Empirically is a fancy word for there's research that supports. There's research that influenced this protocol's design. So the elements of all of these protocols are based upon research. It's how to best apply that research that many academics might disagree just a bit. And if you really think about it, and you look at all of these protocols, they're not a heck of a lot different from one another. There are elements of disagreement on the utility and efficacy of certain aspects of all of these protocols. But in large part, they're extremely similar. Nearly all of them, if not all of them, have a rapport building phase. All of them have an abuse scenario phase, where one needs to question the child about the abuse that's alleged. What happened? All of them have closure. That is, there's a section of the interview protocol that recommends to interviewers how to wind down, how to end the interview. Now, there is some disagreement in the field about the use of anatomical dolls. There's some disagreement on the use of stick drawings or drawings and graphics. There's some disagreement on ground rules and making a child take the oath. That is, that they swear on a Bible or some other way that they'll tell the truth. And that they understand the difference between fact and fiction. They can tell the difference between a truth and lie. You know, if you do that and how you do that, there's some disagreement about among professionals. Now, this evening, I'm not going to present slides on the Finding Words Corner House protocol. I'm going to do that next week. But I want to touch on a couple of things that are relevant to this and relevant to your last learning project. There's two cases that are among your required readings and also part of Learning Project 4, I believe, called Idaho versus Wright and State versus Delgado. Now, those cases are important for a few reasons. First of all, there's a hearsay exception in child sexual abuse cases that may be applicable, and Idaho versus Wright is the first Supreme Court of the United States case to take a hard look at that kind of hearsay exception. In that case, there wasn't a specific law in Idaho. Rather, the Idaho law enforcement and Idaho legislature had a residual exception, which means a catch-all exception, which means that even though there are rules against hearsay, there are exceptions to those rules. And one exception is called the catch-all. And it simply means if there's not a specific rule, you can use this rule if it's important to get that hearsay in and it's defensible and it makes legal sense without getting into residual exceptions. It's not specific. A specific hearsay exception might be a dying declaration, somebody who on the eve of their death makes a statement, or a statement against interest. A statement against interest is, yeah, I robbed the bank. I needed money to feed my family. Well, that's hearsay if someone else is going to tell you that a person uttered those words. But it would normally be admissible because it's a statement against that person's interest. It could get them in trouble. And the whole point of the prohibition on hearsay is that it's found to be unreliable. It's easily... a statement can be easily made and not subject to cross-examination. But a statement by a person that he robbed someone or killed somebody and made that statement to a third party, that has a greater degree of believability or reliability because they said something that could get them in real trouble. So it's more likely to be reliable, more likely to be true. So hearsay's definition is an out-of-court statement, a statement made not in the courtroom, that's offered in the courtroom by some other witness. So if Franklin tells us he saw a car hit that series of sculptures in front of College Hall and describes how some student was injured by the flying debris, and he says that to the DYFS worker, and the DAG puts the DYFS worker on the stand, or the prosecutor puts the DYFS worker on the stand to say what Franklin saw and what he said about what he saw, that would be objectionable under hearsay analysis. Because it's an out-of-court statement. Franklin spoke to the DYFS worker outside the courtroom. And now the DYFS worker's offering it in court for the truth of it. That we want someone to believe that the car crashed into the statues and flying debris from the statue hit the student and injured them. I like to call the hearsay rule the best witness rule. Who's the best witness to tell us what happened when the car hit the statue and the kid got hit with the debris? Not the DYFS worker who spoke to Franklin, but Franklin himself. Anything else is hearsay. When you tell us what some other person looked at or said or did or experienced, it's always hearsay. Now, whether it's admissible or not, under the rules of evidence, is a different story. There's a lot of exceptions to hearsay. One of those exceptions is for kids under 12. It's called the tender years exception to the hearsay rule, and we talk about this in Children in Justice. Excuse me. Tender years exception. Rule 803. That's the rule numbers, 803, little c, 27. That allows kids under 12 and under rather, who make statements about sexual abuse to have their words repeated in court by a third party. So hearsay may be admissible if the declarant, the person who said the hearsay, is a child under 12 and under. No, it's under 12. I misspoke. It's less than 12. If the child is less than 12 and makes a statement about sexual abuse, and the court finds it's trustworthy, then that evidence could be admissible before a jury or a judge trial. We call that the tender years exception to the hearsay rule. The rules are kid under 12, sexual abuse on that child. Not they're a witness to it, but they're the victim of it. If you're a victim of sexual abuse, you're under 12, and what you said is considered reliable, then your statement, the child's statement, might be admissible, even though it's hearsay. And that's kind of relevant to Idaho versus Wright and State versus Delgado. Because Idaho versus Wright was about that residual exception to the hearsay rule being applied in a child abuse context. And in part, the defendant argued that he didn't have the opportunity to cross-examine the child on that issue. That is the allegation of abuse. He said this violated my right to confront the witnesses because the Idaho residual exception was allowing in the statements of the child who was unavailable and didn't testify. And he wanted it thrown out. Well, ultimately the court said, nah, hearsay exceptions are okay, provided that they're trustworthy. And what's important is, for your purposes, they gave us guidance on what the factors are to look for to determine whether a child's statement is otherwise trustworthy. And those factors not only apply to Idaho versus Wright and Delgado, and those factors not only help the judge or the fact finder evaluate the evidence, evaluate whether this child's statement is trustworthy under the rules of evidence, but those factors also allow the court to size up whether the child's statements are believable at all. And some of those same factors would govern what a DAG or a prosecutor argues in front of the judge. They're credibility enhancers. And in Learning Project 4, you'll see that I gathered them up for you because you're going to look for those kinds of things in a video of a forensic interview. Kinds of things that make the child's hearsay statement believable and reliable under the circumstances. The lessons of Delgado and Idaho versus Wright are, that is, the lessons on what to look for to demonstrate the credibility of the statement or statements, and maybe even apply the hearsay exception. The courts say, look to the spontaneity and see whether when they tell the story again and again, which we discourage, but it happens, if they state the allegation on more than one occasion, is there what we call internal consistency? Are they saying something now that they said before consistently? Was there a prior interrogation that renders the spontaneity suspicious? Did a caregiver prime the child, ask the child a lot of questions in an aggressive way, ask leading questions? Was there a prior interrogation of the child or aggressive questioning of the child that might render spontaneity suspicious? The other things you look at are the mental state of the child. Whether they use age-inappropriate terminology, whether they have a motive to fabricate, their affect, their demeanor, their emotions, any developmentally unusual sexual knowledge is relevant. Because if it's in the case and if the child uses words that are beyond their years or describes body mechanics or ejaculation or something distinctively sexual that they would have no basis to know, if they have developmentally unusual sexual knowledge, that's persuasive to a court. On the other hand, we hope that their terminology is age appropriate. That is, they call a penis a wiener instead of something else, a more graphic term. If the child makes a statement of interest, a statement against interest, that might be a credibility enhancer. What might that be? Well, we investigated and I prosecuted a little girl who was involved in a high-speed chase when the guy who was molesting her saw the police in his rearview mirror in Eastside Park. They took off, they crashed through a fence, they drove over lawns. She was shaken up, he was injured. And she had no panties on, they were inside her pocket. She was 8 years old. She had on a dress with no panties and a t-shirt. When questioned at the scene, she told the woman police officer some of what happened. But she was reluctant to talk to the detective because she was worried that her grandma was going to give her a whooping. I can't tell you because I'll get a whooping. And eventually she does tell. Well, if there's a kid who makes a disclosure or a statement about these things, and they think not only that it's going to get them in trouble, but they might even be physically assaulted or punished severely, why would they tell us? A statement like that, that's so far against their childhood interest in being safe. Why would they make a false allegation about sexual abuse if that's a big issue to them? This little girl, we saw the panties in her pocket and asked her for them, and then we tried to question her for a little while. In the beginning, she wouldn't talk. She kept saying, my mama's going to give me a whooping. My grandma's going to give me a whooping if I tell. Eventually, we made her comfortable enough where she did tell. So when the judge is looking at that video or that statement, if there's no video, one of the things that the DAG will highlight is, look, this kid made a statement against her own interest. She thinks she's going to catch a beating for telling this. People generally don't fabricate things that are going to get their butts kicked. they usually fabricate things where there's an advantage, where the deception is going to pay dividends in getting them what they want or need, or getting someone away from them that they find undesirable, or manipulating someone. Why would they lie if they think that it's going to give them a beating or get them a beating? So that's important, says the courts. Whether the child has any motive to fabricate, whether the child disagrees or corrects the interviewer, is very important. Because that shows the kid's paying attention. That shows the kid will correct us grown-ups, because they defer to us grown-ups tremendously. But that shows that the child will not defer simply to the grown-ups, and will correct the interviewer, and feels empowered enough to correct the interviewer. And if they correct the interviewer, that gives us more confidence in the child's other statements during the interview. It gives us more confidence that the child will not let the interviewer put words in her mouth or make statements that aren't true. It shows that that kid is not afraid to say, hey, you messed up. You made a mistake. That is a very powerful way to enhance the credibility of your video or your child's statement. And in the juvenile courts, the kid will testify. Excuse me. And the kid testifies in the criminal courts as well, but in the juvenile courts and the family courts, the kid will testify before the advocate puts on their case. And the judge will be able to size them up as well. In the criminal courts, we get a pretrial ruling. In the criminal courts, we ask the judge to rule on it before we begin the trial, so we know what we're going to say to a jury in our openings. And we know what to prepare for during the case. If there isn't going to be a video, you prepare. If there is not going to be a video, you prepare one way. If there is a video, that is a video recording of the child, you might prepare differently. So those are the factors that are in Idaho versus Wright and State versus Delgado. What I recited to you are the factors that a court might look for, and maybe even more, but those are some of the basic factors that a court is interested in when we do interviews with kids. Those are Idaho versus Wright and State versus Delgado. Yeah.
So generally hearsay is not accepted in the courtroom, but there's hearsay exceptions.
Right.
And we talked about those, but generally they're not.
Right.
Okay.
The child has to be under 12 for the tender years exception to the hearsay rule to apply. And there are other exceptions too that we talk about in Children in Justice. However, in child protection practice, the hearsay rules are less rigorous. You can get reports into evidence if they're a certified business record. A report is hearsay. You can't cross-examine a piece of paper. And if you really want to appreciate hearsay, think about it in terms of cross-examination. You want the best witness possible, and you want to be able to challenge them. So a police report, it involves the statements of the police officer. He must testify, not in child welfare practice. Once in a while, evidence is limited, but most of the time, you can mark statements and reports as documents, videos, and the court will accept it into evidence, depending on whether you could show that it's relevant. So you have that tender years exception in the hearsay rule. You have the courts telling us what to look at in kids' statements to determine whether they're trustworthy or reliable. And remember, that's one of the elements of the tender years exception. Statement about sexual abuse by a kid under 12. Right? That sexual abuse was perpetrated on that child. If you have those three elements, all that's left is to show that the statements were trustworthy. And the factors to review, I just went over. The trustworthiness factors. And that will loom large in Learning Project 4. I want to talk a little bit about anatomical dolls and their use, and we'll see some video clips in the future about anatomical dolls. We don't call them anatomically correct dolls, not anymore, because they're not correct. They're disproportionate. We simply call them anatomical dolls. Not even anatomically detailed dolls, just anatomical dolls. And they can be very helpful in allowing kids to express themselves. Anatomical dolls help kids to say what they cannot say. Because anatomical dolls permit the child to show us what happened. And in that way we can usually get more detail, and it also allows the child to distance themselves from the abuse. So when they're showing us with the dolls, it creates a distance between the child and the abusive events, and they might be more likely to talk. It might give us even more information. But in order to use anatomical dolls, you have to recognize that there's a process. We only use anatomical dolls once there's a disclosure by the child. Because the purpose of the dolls is to help a child clarify and explain things that they've already said, that the grown-ups don't understand. If they say, Daddy was rubbing on me with his dingle playing the widget game, tell me more about the widget game. And they really can't express themselves. You know, I have these dolls. They're not the kind of dolls that we play with. They're not toys or anything like that. They help me talk to kids. And they have all the parts you have. And if we had the dolls here, you would show them very briefly, the genitals and the butt and the chest. I'd like you to show me what grandpa, what uncle, what dad did, whoever the person is, when he played the wiggle game. often kids make statements about a lot of things, especially sexual abuse, and they really can't articulate exactly what's going on. They don't have the universe of language to express themselves well enough for us to understand completely what they're trying to say. But if they show us and they narrate while they're showing us, then we typically get more information and good information. Excuse me. You want to encourage the child, right? The child to do the talking, and you to simply say, what's happening next? What is Uncle Miguel doing now? What's the little girl doll doing now? Or what are you doing now? What's the doll that's you doing? What's Uncle Miguel doing? What's happening next? What is he doing with his hand? I see his head is down by your legs. What's happening there? Right? The child is given 2 dolls that are age appropriate and skin tone appropriate and asked to show us what happened. And then they do, or they attempt to. Before you do that, you have to test for this thing that you need to remember called a representational shift. Representational shift. The representational shift is a cognitive ability that usually happens around 4 or 5 years old. And that means that the kid can see themselves outside of their own body. The kid can express symbolic memory. They can see that some object is representative of them. And some little kids can't do that. They think the whole world revolves around them. They can't see themselves outside of their own body. So they have a tough time if they can't make the representational shift. And you certainly can't use anatomical dolls with them. Because if they can't use symbolic memory, if they can't appreciate that those statues are symbols of some other people who aren't real, or that G.I. Joe isn't real, it's just a toy character. If they can't see themselves outside of their own body, then they're not going to do a credible interview with the dolls. Because that means they cannot picture the doll as them. To them, they're them, and that's Dolly. We're trying to say, well, just imagine that Dolly's you. Show me, and this is Grandpapa. Show me what he did to you. And if they continue to lift their shirt or touch their own bodies and they're not interacting with the dolls, you go, stop. In your mind or with your team, I don't think this kid can make the representational shift. If they can't see some object as symbolic of them, then they will not be able to use dolls, because that's what the doll is used for. It's symbolic of both parties to the equation. But once the child can make that representational shift, then they can be witnesses You just need to make sure that the child understands the obligation to tell the truth. That's something that they should be able to express confidently to you and ultimately in the courtroom.
Can you explain that a little bit? Is that a test to tell the truth? Are you testing to see if they
Well, the requirement is that the child is able to testify competently. Competence for any witness is defined as understanding the nature of the oath, that when you swear to something, it's really, really important. You're swearing under God or affirming. So that's one part of testimonial competence for a child or anybody, really. The next part is, can they differentiate from what's real and imagined or fantasy? And if it's clear that you can differentiate from what is real and what's fantastic, and you have the cognitive ability to remember stuff, which that's what a witness needs. They need to be able to remember what happened in the past and express it. Those are the three elements of competency. Now, the question was, how do you test for that? And you'll see next week when I talk about finding words that we don't recommend testing for it. But many, many jurisdictions test for it. I mentioned last week this a little bit when I said, if I told you this thing was a pencil or was red and this was black, would that be the truth or a lie? That's called the truth-lie ritual. And many law enforcement did that for very many years. And not so much anymore, but other jurisdictions still require it. Most do. To me, that's just about testifying. We're doing these videos of the kids 2-3 years in advance. By the time it gets to court, some years have passed. So we want to rely on the hearsay statement from the video. But the only time competence becomes an issue with regard to nature of the oath, obviously, we're in no oaths by us. Nature, when I say by us, we don't use the oath in interviewing a kid on video. When they use the word oath, that tells me this is a courtroom thing. So we don't test whether the child understands the oath. We don't test whether they understand the difference between fact and fiction and fantasy. But you'll see when we do Corner House Finding Words, we recommend that you look for opportunities during the forensic interview to reinforce or enforce or introduce these important issues. Like if the interviewer makes a mistake, rather than at the beginning of the interview saying, you know, my name is Joe, if I make a mistake, you could stop me. You could say, Joe, you made a mistake, and I'll go on. Well, often, that kid is half paying attention, or it goes in one ear and out the other, or they're looking at your shirt or your tie or whatever. It's not sticky. It's not sinking in. And sometimes they're expected to learn that from reading a pamphlet and working with their mom or something. But our point in Finding Words is that's about testifying in court, not making a statement to us. People make statements all the time and they're admitted in court. They're not sworn or they don't involve taking an oath. Nevertheless, even in those states that still want some truth ritual, some testing of their awareness of the truth-telling requirement, the trend is towards not using simple inquiries like, if I told you this computer was a hat, would that be the truth or a lie? That kind of inquiry is not sticky, it's not effective. So why do it? Especially if it's not a testimonial situation. we do recommend is, in Finding Words Corner House, is when you make a mistake, you thank the child, you emphasize that it was okay, you tell them that ground rule as it happens. And if we're worried about competence of the child, it's our belief that if you watch the entire interview, usually 20 minutes to 40, you can assess a child's competence by watching and experiencing that interview. By watching that interview, you can draw conclusions about whether there are issues of competence with that child. And if you want to take it to the next level and then interview the child or do truth-lie rituals with them where you have a concern over their competence, especially with the truth-lie issue, you might want to use one of these protocols that doesn't rely on saying an object is one color or another color or that kind of stuff. There are a series of drawings where a child picks out the boy who's remembering the bull. And if his teacher asked him what the bull's name is, and he said something different than the narrative says, what would happen to the boy? If the boy lies about the picture over his head, what would happen? Well, he'd get in trouble, it wouldn't be good. You get answers like that. So I don't have that here. I'll show that to you next week. But there is a way to test on the front end. We just recommend that you test during the interview and you size up the kid's competence by looking at the entire interview. And, if they got problems, it'll manifest itself. You'll see it on video. I can predict nearly every case where a kid is developmentally disabled or has cognitive impairments or really doesn't get it. You spend 35 minutes with them and you look at how they express themselves, you'll figure out whether they got issues or not. You don't need to run some pop culture test, some armchair analysis at the beginning of the interview. Any questions about that?
If the child proves to not be a good witness, is your case screwed?
Well, it depends. Very often the answer is yes. But if there is extrinsic evidence, corroborative evidence, like medical evidence or an eyewitness, which is extremely rare, but if the whole case rests on the child's shoulders, which we try not to do, then the case is over. You're not going to win and you lose. But you can always plea bargain. You don't have to tell the other side, why you think it's not winnable or prosecutable. And you don't have a lot of those because in my jurisdiction, I instituted many years ago attorney review. So in order to get to the next level, it's not a detective's decision, it's an attorney's decision. And the attorneys can be very, very conservative in charging because they don't want to, these cases are hard enough with a good case. You certainly don't want to go to court with a lousy case that you're going to lose inevitably, and the kid is going to be even more screwed up if you lose the criminal case. So, what was your question again?
I just was that you answered it, whether your case was pretty much screwed if you have a child who's not credible. But in that case where you either don't prosecute or you have a problem with the prosecution, and what if DYFS had already claimed that these were substantiated charges? Is the child still going to stay in foster care or wherever she's been, or does she then get returned to this abuser? If we think, let's just say we believe she was abused, she's just not a credible witness.
Well, as my colleague Lauren Carlton was saying today, we did a training, Franklin was there, and was someone else there from this class?
Yeah, just married.
Where's she hiding?
No, it's 3 ways.
Well, remember she kept saying there's what we know and what we can prove, And for criminal prosecutions, what we know and what we can prove is more difficult than for child protection. Unfortunately, often child protection, DYFS, marches in lockstep with what the prosecutor does. But it ought not be that way because you only need a preponderance of the evidence to prove abuse or neglect. And if the division feels that a child is at risk yet the prosecution can't make a case and we decline to charge, they'll take action. You can still protect that kid. And ultimately, a DAG can prove in a fact-finding abuse or neglect where we probably couldn't in a jury trial. Most cases, if it's so flawed that we're not going forward, DYFS isn't going forward either. But theoretically, they could go forward, and sometimes they do.
I think that the question is whether the child goes back to home of the perpetrator or not.
Well, if DYFS doesn't substantiate, we close the case. We don't think we can win it.
That's a DYFS decision.
Well, that's what the question leads us to, right? She said, you're right, her question was, a prosecutor, if you don't charge and you don't think the evidence is good enough, do the kids go back to the house with the molester? And my whole point was, well, DYFS can continue doing what they're doing because they have a lesser standard, because in order to keep the kids away from the molester, they have to believe the original allegation is sustainable. And they can, and you can, if you can show by a preponderance of the evidence to the satisfaction of the judge that this child was abused. If DYFS doesn't believe, if Child Protection doesn't believe they can prosecute even in the civil court by a civil standard of proof, then the kid goes back and lives with the molester. You hope?
I don't think it's that straightforward. I think if the kid goes back, if you said to safeguard yourself, and you would expect some kind of cooperation from the molester.
And they say, no, I'm not cooperating with you. Go pound salt. Well, now you need to substantiate by preponderance of the evidence. And if you want to compel them to do what you want to do, you need to have a DAG litigated and prevail, right? If you want to do that. I'm talking about, look, maybe I was being too blunt. We're going to do our best not to let kids go back in dangerous homes. And in homes where bad guys we think molested them are. But unfortunately, there are more than a few cases where we can't do anything and DYFS can't sustain its burden. And kids are, in a situation where the guy may be a molester.
I think it also depends a lot on the kid, what the kid is saying. That case where I think it was much clearer years ago, whereby the father was molesting his son, but the kid would not admit to it.
That's right.
The mom was convinced, and there were all indications that the child was mental, but he would not admit to it.
We have two. I mean, I've not had in 20 years almost of prosecuting child abuse. I've only seen two of these cases, and they both have been within 60 days this year of one another. One was day before yesterday, and one was a month and a half ago. And they are girls, female children, prepubertal, 8 or 9 or 10, that have internal vaginal injuries, lacerations, and severe bleeding trauma to their vagina. Now, the last girl said a lot of different things. She came home from a party. A party in that it was a christening or something. She was at a family event. Maybe she was 10 or 11 or something like that. The family said, oh, let cousin Mikey take you home. He's a 21-year-old guy who lives in the upstairs apartment in an extended family, multiple apartments. So she's hanging out with cousin Mikey, and next thing you know, fast forward to us, her vagina's sliced, severely traumatized, and she's in a hospital getting stitches. Sadly, the first time she said nothing happened. The kid upstairs don't know anything about anything. The doctors can't tell us much other than something caused this trauma. I don't know what. We all know that. Hours later, she says the dog did it. Some dog on the floor that she resides on. Her story made no sense. We know the dog didn't do this. We don't know who did it. And she told us, now she's competent enough to tell a narrative. But she says the dog did it. He says he don't know what happened. the parents and the caregivers and the people around her want to believe the dog did it. Life is a lot better if the dog did it than your nephew or the guy upstairs brutalized her. I don't know if he did, but he's my number one suspect. You know, there's a saying in the law, it's Latin, and it goes like this: res ipsa loquitur. And it simply means the thing speaks for itself. And while it's not that clear cut in this case, there are elements of it. You know, I say, wait a minute, girls at the christening, nothing wrong with the vagina. Girl goes home with jerky 22-year-old, spends 3 hours with him, she's bleeding and traumatized. Never mentions the dog until hours later at the hospital when cops are coming, people are concerned, DIFAS workers are running in and out. There's chirping and buzzing going on around her. All of a sudden now, the dog did it. We don't believe the dog did it, but we can't prove who did it. Well, she's home and living in a house, and guy's upstairs, she's on the second floor, and life goes on. Day before yesterday, got another girl. This girl was injured so severely she has sutures internally in her vagina. We haven't interviewed. They may have interviewed her. I was out all day today, but the initial report is she didn't have anything to say about it. And she has a lot of mental health issues. They're suggesting that maybe she stuck an object in there or harmed herself, that she was self-injurious. But the doctors seem skeptical of that, and the depth of the trauma is significant at first evaluation. You know, we need to get all of the records and interdisciplinarily discuss all of the evidence in this case before we know what we got and where we're going. But she was supposed to come in today and be questioned. But the early information is that nothing happened. I went to the bathroom and this just happened. Now the thing is maybe this one is self-injurious. I could sleep a little better about this case in the end because I know she's got mental health problems. But, you know, and I haven't reviewed all that CSI brought back. The crime scene investigators went. We, looked for blood everywhere in the house, and we looked for instruments of trauma, and those kinds of things. Interestingly, the mom's boyfriend who lives in the house, she accused of molesting her in September. But when she came to our office, she recanted. When she went to the children's house for an extended psychosexual evaluation, or whatever they call it now, trauma assessment, that's the right term. Not even in an extended trauma session did this child make an additional allegation or confirm her original allegation to some school grown-up that her mother's boyfriend had molested her. Before this boyfriend, mom took up with a registered sex offender under Megan's Law, and he molested the girl and the other kids. He's in jail pending trial. So this is the household that this kid lives in. Now, the early information among the detectives is the accused boyfriend was appropriate, and he's the one who called the cops, and he did A, B, and C, and there was a lot of things he did that arguably are inconsistent with guilt or culpability. But the jury's still out. But no disclosure and no confession? I don't think any agency's doing anything, unfortunately. No matter how spectacular the injury. Now, the case that I mentioned at first, where the boy 21 lived upstairs and the dog allegedly did it, we didn't stop there, and she said nothing happened. I didn't buy it. I mean, we brought in the dog, we interrogated him. He was a tough nut to crack. Dogs are tough. Yeah, I don't speak German Shepherd. I only speak Yorkie, but we brought in some culturally diverse interviewers. We brought in the 21-year-old, whatever his age is, the 20-something. We spoke to him assertively, he was not having it. He didn't do nothing. He's wrongly accused, and nothing happened. He don't know what happened. He wasn't involved. He didn't do nothing. So if the prime suspect says nothing happened, the victim says a dog did it, there's no eyewitnesses. There's a case where that kind of spectacular trauma does not just happen. I'm sorry. But we got 2 of them, and sadly, neither case is prosecutable. Well, the other one might be. We're still investigating that. Any other questions? Okay, look, I had a long day, and my day isn't even over yet. I have to go coach 2nd and 3rd graders and teach them about basketball now for 3 hours. So I've been teaching since 8 o'clock this morning, or thinking about teaching since 8 o'clock this morning, and teaching since 9 o'clock this morning. And I'm about to face my toughest audience yet. So go to the coffee shop if you got another class, or study your assignments, or catch up. Let me just make a few comments. I gave you extra time to do the learning project information gathering. The reaction paper's due December 5th. You don't have the aggregate of your work yet. All of you submitted either a Word doc or an Excel spreadsheet with your research, your interviews. What I'm going to do is I'm going to put that all on one spreadsheet and post that on multiple places so there's no problems getting it. And then you'll write a reaction paper. I will not have that till the earliest Friday morning. Okay? So you can't do Learning Project 3 Part 2 until probably Friday or later this weekend. But, the other part, I gave you another 24 hours because some of you couldn't open that, right? You couldn't open those Excels. I'm not sure why, but we'll see. Well, your discussion board you got to do. Whatever it says you got to do. Do your discussion board. It's due whenever it's due here. Is that what it says, the 5th?
Reaction paper.
Oh, the reaction paper. Yeah, the discussion board is due the 1st and the 5th.